Just testing that everybody can hear me.
Yes, good morning, Chairperson. We can hear you. I can hear you, at least.
Okay, awesome. Maybe let us just give maybe the other members a minute or two, and then we shall start. The rough one form today and the implications thereof, which span a number of areas. One is, I think the most important, obviously, is the impact on claimants and the financial demands thereof on claimants. We have, during our hearings, spoken about the right to access government services and to access them in different ways. One, for it not to cost you exorbitant amounts of money if you're a citizen. And secondly, as Honorable Kubeka has noted and other members have as an example, the fact that it is in English, there is the complexity of the form, but there's also been extensive litigation over the matter. You will recall that we have had the Law Society talking about this. We have had the Legal Practice Indemnity Insurance Fund talking about it, and the litigation compared thereto, etc. So part of the report drafting process included extensive research by or significant research by the Secretariat to make sure that we cover all angles, because there are judgments that have been given over the relevant section of the legislation where the courts have provided a guidance on how it is to be interpreted and how the Road Accident Fund should apply it, etc. So it is a fairly lengthy document. We had actually initially thought that we could do more than one section today. But if we take the previous experience of how we dealt with the other sections, it's clear that this is going to take us a significant amount of time. It's about 27 pages long. And in that, Ms. Ibrahim is going to go through the document itself, and then all the members will get an opportunity to comment on the relevant section. So without much further ado, let me hand over to you, Ms. Ibrahim, to take us through the document. If any of the members have not yet received the draft, please let me know, but it was sent on Wednesday this week. So over to you, Honorable. Sorry, over to you, Ms. Ibrahim. Sorry, I said Honorable Ibrahim now. Just
Good morning,
installed you as a
Chairperson.
member.
Good morning,
speaker.
Chairperson. Chair, I'm going to ask the Secretariat to please display it on the screen because I'm using my soft copy that's in front of me. Chair, as you indicated, it's a long section, but it was important for us to set out the order of events so that members can properly understand the context that led to the adoption of the form, and then answer these questions as to whether the litigation is justified and the ongoing use of the form, because that then impacts on whether the costs are justified, because ultimately that is the main concern of the committee. So, Chair, just as a reminder to members, Section 24 of the RAF Act requires that a claim for compensation must be set out in a prescribed form. And it then goes on to empower the Minister of Transport to make regulations on any matter that may be prescribed. And there are a number of matters that the Minister has to make regulations on in order for the Act to work. And that form that the Minister prescribes is what we typically refer to or understand to be this RAF1 form. So there was a RAF1 form that was published via regulation by the then Minister in 2008. But at the same time, as part of that set of regulations, the Minister also then purports to give the power to amend or substitute the RAF1 form to the RAF itself. So extremely unusual, because already regulations are delegated legislation. So you wouldn't typically see that that happening. But be that as it may, Section 24.4, Denzel, I'm only on point 2. Sorry, I'm explaining more than what's on the document. In terms of Section 24.4 of the Act, any form referred to in that section, now meaning the RAF1 form, which is not completed in all its particulars, shall not be acceptable as a claim. So our courts have made it clear that this RAF1 form is really your gateway to claims for compensation, because if you can't pass the stage of lodging that RAF1 form, then in effect you won't have a claim and your claim is going to prescribe. And members will recall we dealt with prescription in some detail in our last meeting. You've got 2 years for a hit and run and 3 years for other claims. So if in that time period you're not able to lodge your claim, then unfortunately your claim prescribes and you can take no further action against the fund. If a claim is registered, so in other words, the RAF1 form is accepted, the RAF can still object to that claim within 60 days. And if they fail to object, then the claim will be deemed to be valid. That's not to say that the RAF then is liable, but rather to say that you have lawfully submitted a claim. So in other words, the RAF would still look at issues of liability and apportionment and everything else that it would need to do. So the RAF Act originally is passed in 1996. But in 2008 is when that RAF1 form that we know as the old RAF1 form comes into place. And that RAF1 form, the 2008 form, was based on what they termed substantial compliance. So as long as you substantially complied with the requirements as per that form, the RAF would accept your claim. So, it asks for fairly simple documents: the identity, the date and place of the accident, the identity of the other party, if known, your medical report, the amount you're claiming, and then you would attach any accounts, invoices, etc., to support your claim. In contrast, the 2022 RAF1 form, which is the new RAF1 form, demands significantly more information. If that information is not given in its entirety, the claim has then been rejected. So in other words, it's all treated as compulsory. And this notion of substantive compliance has essentially been thrown out of the window. So in addition to the usual things that one would expect, like proof of identification, the medical reports and so on, there's also a whole host of additional information that's required. So for example, if you're making a claim for in respect of general damages, you would need all your hospital and medical records. For loss of earnings, you need those medical legal reports establishing your injuries, proof of injuries, including photographs, proof of your income, you need itemized tax invoices in respect of past medical expenses. And those are just some of the examples that the committee would have heard during the inquiry and that we dealt with in some detail. So where a claimant can't provide all of those documents, you won't be able to lodge a claim. So I've put a few examples in paragraph 8 of claims that would be rejected outright under the 2022 system. So one, a claim of a foreigner who's unable to supply proof that they are legally in South Africa. So it doesn't matter that they've provided proof of their identity. If they weren't able to show that they were here legally, that claim would have been rejected. Members might have read that the SCA ruled, I think just last week on the 16th of April, that the way in which the Act is drafted, all persons actually would include foreigners, regardless of whether those foreigners are legally or illegally in the country. That is, of course, a whole other legal debate, and the court goes into some detail where the judgment speaks of the fact that, the court is not just looking at the literal interpretation of that phrase of all persons, but also at the objectives of the Act and so on. But that's just an example of one that would have been rejected outright. Similarly, a person who's unable to supply medical reports establishing or substantiating their temporary or permanent disability and loss of earnings, that would also be excluded, notwithstanding that those reports are, of course, extremely expensive. And then a claim of a worker in an informal trade who's unable to provide a payslip, that would also be excluded, notwithstanding that that person has never had a payslip, doesn't have access to a payslip, that they simply wouldn't be able to comply. And then a claim of a minor in the absence of an unabridged birth certificate or court order or master's letter of appointment of guardianship, as the case may be. So, members may know that not all children necessarily, their parents necessarily have copies of their unabridged birth certificates, and sometimes these documents take time to get from the Department of Home Affairs. But if you don't have it, then unfortunately your case, your matter wouldn't have been lodged at all. So this RAF1 form, the 2022 RAF1 form, it can be traced back to March 2021. And as I indicated at the beginning, the context is important for us to unpack what exactly happened. And what I've done is I've tried to put it in a timeline so that we can understand the sort of haphazard toing and froing process that unfolded in this bid to adopt this new form. So we're starting off prior to the adoption of the form, just to show what sort of information the RAF would have had at its disposal when it tried to change the form. So in December 2020, there's a landmark judgment that the Supreme Court of Appeal hands down. And it's known as the Busuku case. It was Mr. Busuku and a number of other applicants. But Mr. Busuku had sustained a head injury, and he had lodged the 2008 RAF1 form, but he left the portion dealing with medical information blank. And instead, what he attaches was a set of hospital records. So almost in that section of the form, say, refer to what I've attached. The RAF had lodged his claim, but thereafter they argued that the form was incomplete and that his claim had prescribed. And the SCA then had cause to interpret Section 24 of the RAF Act. And the court distinguishes between peremptory and directory statutory provisions. And the SCA finds that the RAF1 form does not call for detailed information. It is not intended of itself to enable the fund to assess the quantum of the plaintiff's claims. It seeks to enable it to investigate the impact of the injury sustained. And in order to do so, the RAF1 form requires the disclosure of information to guide and facilitate the investigation. So the court is very clear that the purpose of the form, the purpose of lodgement, is not that somebody can sit behind their desk and immediately decide this is what person X should be entitled to. In fact, there's an investigation procedure that must be undertaken. And the information you provide at this stage is merely to enable the RAF to commence with that. So the Basuku case affirms this principle of substantial compliance, which the courts had dealt with prior to this judgment even. And this legal principle of substantial compliance, basically what it allows is that where there's minor deviations from procedural requirements, provided that you meet the essential purpose, that would be regarded as substantial compliance. So in the case of Mr. Basuku, the fact that he didn't fill out the necessary information in the form itself is neither here nor there, because everything that he's attached speaks to the information that the RAF would have required at that point. And there's even case law as far back as 2014 where the SCA speaks of the RAF 1 form. And again, the SCA says the form is peremptory and that the prescribed requirements are directory. So all you needed is substantial compliance. So at this point, the RAF would have been well aware of what the purpose of the RAF 1 form was and what its intention was, i.e. that it's not meant to enable the RAF to assess the quantum of a claim, but it's rather a gateway for the lodgement of a claim. And the courts, of course, do that because they want to give the widest possible protection to claimants. So it's in this context now that members need to consider what the RAF then does. So knowing that there is this interpretation of substantial compliance and that the courts have articulated what the purpose of that RAF 1 form is, we then get to 2021, where on 8th of March, the RAF CEO, at the time, Mr. Litswalo, and the board chairperson issue an internal management directive calling for compulsory information to be submitted when lodging a claim. And they send this internal management directive now to all attorneys, and anybody that's wanting to make a claim is then alerted to this management directive. And this directive then gives an extremely long list of documents that are now compulsory. And the effective date is 1 April, which is just merely 3 weeks from the date on which this decision is made. We know that on 28th of April, the following month, that the board approved the change in the accounting policy and the use of IPSAS 42. And the reason I've put it in here is because it is important in the broader picture to understand the impact of this RAF 1 on the claims liability. So following the 8th of March, the internal directive, which is now not something that is in the form of regulations or gazetted. As I've indicated, it's merely an internal document. On 4th of June 2021, the RAF then publishes Board Notice 58 in the Government Gazette. And this board notice merely mirrors exactly what was contained in the management directive. And at the same time, they also substitute the RAF 1 claim form. So in other words, they now say instead of using the 2008 RAF 1 claim form, you need to use this new RAF claim form that we've included in these regulations. And they make this regulation on the basis that the minister has empowered them to make regulations on the RAF 1 form. On 14th of June, so within the same month, just a number of days later, the Legal Practice Indemnity Insurance Fund, the LPIFF, together with several other claimants, institute review proceedings in the High Court, and they challenge the legality of that management directive, Board Notice 58, and that new RAF 1 form, as well as the constitutional validity of this power of the RAF now to make regulations on the RAF 1 form. The argument being that the minister could not have subdelegated that. And this is what we heard in the committee being referred to as the Mautla matter. The LPIFF obtains an interim order then interdicting the RAF from enforcing that management directive. What the RAF then curiously does, just a couple of days thereafter, on 22 June, is that they issue another board notice, which is board notice 65, where they then withdraw board notice 58. Board notice 58 is the one that's now being challenged, and they withdraw the implementation of that RAF1 form. But notwithstanding that withdrawal, on the very same day, they then publish another board notice titled Draft Terms and Conditions upon which claims for compensation shall be administered. This board notice, which is board notice 66, I know it gets really confusing, but this board notice again merely mirrors what the previous board notice had said, except now they call it a draft. And of course, this all mirrors what that initial management directive had said. But clearly here the RAF is suddenly alive to the fact that they should have followed sort of some public participation process, which is why they now frame it as a draft document. And Mr. Harbin, you'll recall, had said to us that the RPIFF had made representations at that stage. On 18th of January, the Basuku matter is now still in court during this period. So notwithstanding that Basuku is being fought in court, the RAF nevertheless had decided to proceed with this management directive and the subsequent board notices. The Constitutional Court refuses application for leave to appeal in the Basuku matter. And following that, the RAF then goes out and seeks an external legal opinion, which they get from senior counsel Advocate Semenya, on the effect of the Constitutional Court's judgment. So basically asking counsel, well, what is the way forward now? And counsel advised that the SCA judgment negates the procedural requirements stipulated in section 24.4. So as indicated earlier, that's the section of the form that says that if the form is not completed in all its particulars, it shall not be acceptable as a claim under the RAF Act. And basically, counsel is now confirming that notwithstanding that the Act says that if a form is not completed in all its particulars, you don't need to accept the form. The courts have found that substantial compliance is sufficient. The fact that the Constitutional Court is not willing to hear your matter means that currently, as it stands, that is the law. And counsel advises that the only way around this now is to amend the Act to specifically state that compliance is peremptory and failure to complete the RAF1 form by the medical practitioner, because this was the issue that was under dispute in that matter, who treated the claimant does not constitute substantial compliance. So at this point now, the RAF would be fully aware of that. Nonetheless, 9 months after the close of the public participation process in respect of the draft form, the RAF then publishes board notice 271 of 2022, being the terms and conditions upon which compensation shall be administered. And that board notice includes a schedule which sets out all the new mandatory requirements and documents. And it says these terms and conditions shall be effected with a due and necessary amendment of the RAF1 claim form. Because obviously you still need the claim form in addition to that list of documents. The actual form itself needed to be changed. So they do that on 8th May, and then on 27th of May, the RAF publishes board notice 280, in terms of which they substitute that RAF1 form. And that's the second attempt now at substituting the RAF1 form. The previous attempt was in terms of a board notice, which they had withdrawn. On 31 May, the RAF then publishes board notice 281, where again now they withdraw another board notice. This time they withdraw board notice 280 of 2022, including the new RAF1 form as contained in the schedule. But they don't withdraw board notice 271, which was the list of requirements. So all they withdraw at this point was the actual form that they had attempted to introduce. And then what happens is that there appears to be some consultation between the RAF and the ministry, because obviously we know that at this point the LPIFF is questioning whether the RAF even has the power in law to be able to make regulations and determine what this prescribed form is going to look like. So on 17th of June, we have a memo that was provided to us by Mr. Harbin that served before the courts, where the DG of the Department of Transport writes to the minister, advising the minister to adopt the revised RAF 1 form in order to resolve a dispute between the department and the fund as to which institution has the authority to publish this form. And there is a handwritten note on the memo from an advocate who's an official in the department, noting that it would be proper that the RAF 1 form was published for comments by the members of the public prior to implementation. Notwithstanding same, despite there being no public participation process, the former Minister of Transport, Mr. Fikile Mbalula, publishes a notice in the Government Gazette on 4 July 2022, prescribing this new RAF 1 form. So effectively, he then agrees with the content of Board Notice 271. And this is the 4 members that we are now referring to as the new RAF 1 form. This is the form that the RAF continues to use. The RAF then initiates urgent proceedings now to review and set aside that board notice 271, as well as the new RAF 1 form, and to challenge the constitutionality again of Regulation 71. The minister does not oppose that application and doesn't participate in the litigation at all. Instead, the minister agrees to abide by the decision of the court. Then on 6 November, we still have, this is now, I know, a little bit confusing, because in the background, we still have the Mautler matter that is running, because notwithstanding that matter was running, the RAF then continued to try to get this new form published. But in that matter, then a full bench of the Gauteng High Court delivers judgment where it says that Regulation 7.1 is unconstitutional. In other words, the minister is not empowered to delegate his power to amend or substitute the RAF 1 form to the fund. That power is already delegated by Parliament to the minister. In essence, that's what regulations are. They subordinate legislation, and the court finds it would be unconstitutional then for the minister to further delegate. They set aside the management directive, which at that stage is already withdrawn, and Board Notice 58. Nonetheless, the RAF seeks leave to appeal that judgment in the Mautler matter. The application for leave to appeal then is dismissed in March of 2024. On 20th of March 2024, the full bench of the Gauteng High Court then delivers judgment in the Board Notice 271 matter. And it declares that board notice is unlawful, and the court reviews and sets it aside. And it also declares that 2022 RAF 1 form as gazetted by the minister is also unlawful and is reviewed and set aside. And that the court says basically you now need to apply the 2008 RAF 1 form. The RAF then seeks leave to appeal that judgment as well in the Board Notice 271 matter. They granted leave to appeal in that matter, but only against a single finding, being the finding that Board Notice 271 is declared unlawful and is reviewed and set aside. The rest of the attempts at appealing are dismissed with costs, but they then seek the reconsideration of the judge president. So where you don't get leave to appeal, you can then still lobby the judge president of the SCA to reconsider. The SCA then in December of last year, so after we had dealt with these matters, granted an application for reconsideration, and the RAF accordingly then gets leave to appeal. I have checked with the LPIFF, and they've indicated that a date has not been set for hearing. Of course, if anything changes, we'll then build that into the report. In respect of the board notice 271 matter, judgments being reserved, but in the interim, the RAF continues to utilize the new 2022 RAF 1 form. So that really is the saga of events that led to the adoption of the RAF 1 form, the 2022 form, and the litigation that followed. So in terms of evidence, we went back to try to understand, and it did come out in evidence as well, as to what the purpose of changing the form was. And really, I think the genesis can be found in the strategic plan for 2020 to 2025, which listed some of the focus areas of the RAF. And that strategic plan noted that the RAF needs to improve its efficiency and that they would issue specific regulations to enhance efficiency and improve sustainability. They had a goal to ensure that all new claims are settled within 120 days so that they can be assisted in addressing the litigation challenges, and that they would also then implement a new integrated claims management system. And we deal with that system later in the section of the report as well. So to this end, the fund then makes the decision, and along with a number of other decisions that the committee is considering, to introduce a new RAF 1 form, which according to them is to make the claims process more efficient for road accident victims. So that's the central purpose according to the RAF. Let's try and make the process more efficient. And according to the very preamble on the management directive, so the very first step in the RAF's journey in trying to change the requirements and the form, the RAF speaks of these strategic plans and the fact that they want to be able to process these claims within 120 days. This decision obviously has been subject to a multitude of court challenges. So in addition, the committee notes that the introduction of the 2022 RAF 1 form has been met with criticism from several quarters, including the legal profession, claimants, the LPIFF, and the Legal Practice Council. And we have public submissions and evidence from all of those sectors indicating their unhappiness with the form and the fact that the form doesn't make things more efficient. So like we did in the section with the accounting policy, what we sought to do here is to check whether the process followed in adopting the form was rational. So did the RAF clearly consider all of the possible consequences and so on, and ensure that it did it in a legally sound manner? And then whether the decision to pursue the litigation was rational and defendable, and what the impact of the introduction of the form is, including the financial and potential financial impact of same. So in respect of the first question on the rationality of the adoption of the process, it's common cause that the RAF first attempts to extend the requirements by means of the management directive, which, as I indicated, was signed by Mr. Litswalo and at the time Ms. Msibi in her capacity as board chair. It's an internal process. They don't undertake any public participation or consultation with stakeholders. And they seek to amend this list without actually at that stage adopting a new RAF 1 form. So merely by means of an internal directive, a letter that is sent out to lawyers, they suddenly introduced a whole long list of requirements as opposed to at that stage already considering the question of, if we want to do this, how would we do it? I mean, of course, it would have been obvious that you would need to amend the RAF 1 form itself, but that isn't done at that point. And inexplicably, it appears from the board minutes, the committee will recall that we asked the RAF for copies of all board minutes for the period that the committee is reviewing, that the resolution of the board to approve this management directive was taken on 10th of March, so 2 days after the directive is signed. So it appears that the CEO then, with the support of the board chair, authorized the implementation of what can only be described as a major decision with legal consequences without first seeking board approval. And in addition, the board minutes do not reflect the content of any discussion or engagement on the legality of the decision. There's no reference to the Busuku judgment. There's nothing in there that indicates that the board discussed the impact of the decision on claimants or any other practical consequences that may flow. We therefore assume that such deliberation, in fact, did not take place. Almost 3 months after that decision, the RAF published Board Notice 58, as I indicated earlier, which was merely a repeat of the management directive, as well as a new version of the RAF 1 form. And it's clear that the publication of that board notice, because you already have the management directive and now you have a board notice saying the same thing, is an afterthought. And it's designed to cure an obvious legal defect, being that the management directive could not be legally binding in the absence of a new RAF 1 form being gazetted. And this view is supported by the Mautler judgment, in which the court indicates that, in essence, what they sought to do was to clothe that management directive with legislative force, which they didn't have. And if there were any doubt about the purpose for which the board notice had been published, paragraph 3 of the notice provided that these terms and conditions took effect on 1 April 2021, so backdated. So in other words, the same day that the management directive was implemented. So the court recognizes that this is just a scramble to try and legalize what was obviously an unlawful decision. The LPIFF then institutes its proceedings challenging the management directive and board notice 58 in the Mautler matter. And this leads to the RAF then withdrawing it on 22 June 2021. However, at this stage, the Mautler matter is still in court, and notwithstanding same, the RAF on the very same day, as I indicated, then publishes board notice 58. Which the content now is exactly the same, except this time you call it a draft document and you now invite the public to make comments. The committee heard evidence from Mr. Harben, who's the general manager of the LPIFF, as well as we also received an affidavit from him, and he indicated that they responded to that invitation to provide comments. And in their response, they indicated that it's their view that only the minister has the power in law to amend or issue a new RAF 1 form, that the additional requirements would have a significant adverse impact on claimants, and that this is important, the requirements did not achieve a balance between the effective administration of claims on one hand and a claimant's right to compensation on the other. So even if we accept that at this point, the RAF wasn't aware of all of these problems, which couldn't have been, because we had the Mautler matter in court already. But even if for whatever reason they weren't aware of all of these obstacles, it's now been brought to their attention in the public submissions. And we presume that there must have been a number of submissions, and other submissions would have echoed these very issues. So in the period following the publication of Board Notice 66, the RAF is also then refused their leave to appeal in the Busuku judgment. This is the stage where they get the legal opinion from senior counsel. And notwithstanding all of this, notwithstanding that you now have the Busuku judgment, you've got the advice of counsel, you've got public participation, input, and the fact that the Mautler matter was still before the courts, the RAF still proceeds to publish Board Notice 271 on the 8th of May. And also then proceeds to publish a new RAF 1 form. Again, I call it haphazard. They then only end up having to withdraw this 4 days later. So clearly there was a scramble behind the scenes where somebody's picked up that, these actions are unlawful, we're going to be challenged. If we challenge, the likelihood of success on our part is slim. So let's try to fix what we can. And the committee questioned when the former board was in front of us whether they were aware of the Semenya opinion. And both Dr. Mabuya and Ms. Msibi confirmed to the committee that they were not aware of same. So at this point, when they published Board Notice 271, the RAF is already being challenged on this question of whether it's the RAF or the minister that has the power to prescribe the RAF 1 form. However, at that stage, instead of allowing the court process to unfold and to wait for the courts to settle that question, they still proceed themselves to publish what they purport to be a new RAF 1 form. And only after they do that, do they then seek to engage the Department of Transport on who has the power. And clearly the outcome of those meetings is that they determine that it's the minister that should prescribe the RAF 1 form, which then leads to the RAF now withdrawing that form again. And this memorandum that I spoke of earlier being addressed to the minister by the acting DG, now asking the minister to gazette the form, because that would then have the force of regulations. We're not in possession of a signed form of the memorandum where the minister has signed. Members will know that the way these memos work, you'd have an originator and then you may have a number of signatories until such stage as the final person then signs off. In this case, it would have been the minister. But notwithstanding that we're not in possession of that signed memorandum, it's obvious that the minister accepted what was contained in the memo, because just a number of days later, the minister then gazettes the new RAF 1 form. So again, I've described it as a last minute attempt to cure a legal defect that the RAF was already alive to. So all this time, you've got the LPIFF challenging the fact that the RAF can't make or can't pass or change the RAF 1 form. So they're aware of it until this point, but notwithstanding, they go off on their own tangent. It further appears that the minister at this point must have been acting under some sort of pressure, because despite that comment in the memo alerting the minister to the fact that there should be public participation, that isn't done. And it's common practice when a minister makes regulations that they publish same for public comment so that they can consider the views of affected and interested parties. So members may see that in some legislation in the country, it clearly indicates that a minister needs to follow a advertising and comment process. Others are silent. But regardless of whether legislation requires you to do that or not, the mere fact that you're taking a decision means that that decision has to be rational. So there are court judgments, for example, that say that it's an administrative decision to pass regulations. And even if you were to argue that actually that isn't true, we have a constitutional court judgment where the court was divided on the issue. So even if one were to say it's not a settled question of law, a minister would always, like any other functionary, be constrained by the principle of legality, which requires that your decisions must be rational. So in this respect, the court held in that LPIFF matter that what we have before us is a memorandum that simply moves the minister to adopt the RAF 1 form so as to resolve a dispute as to who enjoys the power to do so in the face of litigation. So the court is also recognizing that the only reason the minister is asked to do this is because the RAF is obviously concerned that there is this issue of whether they or the minister has the power. And the court says that that alone cannot suffice to defend the minister's decision from challenge on the grounds of rationality and legality. To exercise a power simply to show that the power reposes with the minister and without regard to the substance of the proposed administrative action is not rational, because it is performative but not based on reason. And on that basis, the court then sets aside the decision of the minister to publish the RAF 1 form. So this is at high court level. But as I've indicated, notwithstanding whether we accept the court's view here that this is administrative action, because the court found that the making of regulations in terms of the Promotion of Administrative Justice Act would constitute administrative action, and where you take administrative action, the Act says that any decision which materially and adversely affects the right of the public must be subjected to either public inquiry or a notice and comment process, or a combination of both. So whichever way one would look at it, you still sit with this lacuna in that there's no evidence here that the minister took consideration of all of the aspects that the minister ought to have in whichever form, whether that was through a public participation advertising process, or whether through some sort of a targeted process where stakeholders were invited to make input. There's absolutely nothing. All we have is that the minister is being told the RAF wants to pass this new RAF 1 form, and there's a dispute as to who should do it. And therefore, to resolve the dispute, we're asking you to do it, because then there's not going to be a legal challenge, without anybody then considering the fact that the minister is not being alerted to the content of the form itself and the implications. The minister then doesn't participate in this litigation that the RPIFF launches, and the minister chooses to abide by the decision. So generally in law, you would choose to abide by a decision where you don't really have any role to play, and you have nothing to offer the court. So by way of example, in this very committee, there are times when SCOPA is cited in court proceedings merely because an applicant just cites everyone. They cite the minister, they cite relevant committees in parliament and so on. But SCOPA would have had absolutely nothing to do with the decisions that are being challenged. In that case, we would always recommend that Parliament abides, because we have nothing to add to the process. We also have nothing to lose. So whichever way you look at it, the committee would have no role to play. Parliament would have no role to play. So you don't want to spend unnecessary money litigating. This particular matter where the minister then chooses to abide would be a little bit strange, because it's the minister's decision. And the minister is then not taking the opportunity to defend the decision and to place before the court what the minister's reasons were. And one then has to deduce that the minister had not considered the impact of the RAF 1 form on claimants. That issue is entirely absent from the memo, which is the only record of decision that the court had in front of them. So it's therefore really of no surprise that the full bench of the High Court finds that in the absence of that information, in the absence of the court being told what the rationale of the minister was, what the minister considered, that they hold that the decision of the minister is unlawful. And I'm not going to read out exactly what the court says, but what's important here is that the court noted that the lodging of a claim is an essential step in seeking compensation under the RAF Act. And the RAF 1 form must not become an instrument that obstructs valid claims, and by so doing visits unfair discrimination upon poor people, contrary to Section 9(3) of the Constitution. Nor may the RAF 1 form infringe the rights of persons to dignity, security, and access to the courts. We do not pronounce upon whether the RAF 1 form as it stands infringes on any of these rights. It would be unwise for us to do so in the absence of reasoning from the minister. But we do affirm that the minister would need to bring the constitutional rights of persons who would lodge a claim into the reckoning in deciding about the contents of the RAF 1 form. So whilst the court doesn't pass judgment on whether these requirements for all the different documents that you need and all the types of information that you need, whether that is lawful or not, the court says that regardless, at the time of making this decision to make this regulation with the new RAF 1 form, the minister would have had to consider that impact, and there's no evidence that the minister did so. So Based on the information available to the committee, the process followed that led to the adoption then of Board Notice 271 and ultimately the 2022 RAF 1 form by the minister cannot be said to have been rational because there's no indication or no evidence before the committee that that decision was connected to the purpose of the act. And that's what we would look at when we consider whether something is rational. What was the purpose of the act vis-a-vis the purpose of the RAF 1 form? And do those two things align? On the contrary, what we have before us is that the RAF ignores legal advice. They appear not to have fully appreciated and considered various court judgments, and that would have gone for the ministry as well, who would have been aware of those judgments. There was no meaningful engagement with public comments, and the RAF embarks on a haphazard process in its bid to introduce these new lodgement requirements. And unfortunately, it appears that the minister, who ought to have played an oversight role and acted independently, merely rubber stamps the actions of the RAF. Notwithstanding same, we thought it's important to know that the committee appreciates that the introduction of the form was initially aimed at assisting the RAF to process claims more efficiently. And we heard evidence from various people that the problem is that when these matters are lodged, sometimes the information is so thin that it makes it extremely difficult for the RAF then to process that. And that obviously then takes up a lot of time and resources for them to get it to the point where they can start meaningfully engaging with that. And so the committee notes the explanations given in that regard. We had Mr. Lance Johnson, the acting regional manager for the East London RAF office, who sought to explain some of that rationale to the committee. However, the committee notes that it's essential that any decision to improve efficiency is taken with regard to practical implications, legal implications, the objectives of the RAF Act. And ultimately, the point of all of that is to ensure that there's a balance achieved between the right of claimants on the one hand and the obligations of the RAF on the other. One cannot ignore what the purpose of the Act is. Any decision taken pursuant to implementing the Act, the rationality is definitely going to be tested against what the purpose of the Act is. And in this case, we know the purpose of the Act is to give protection to victims of road accidents. At the same time, you also want to ensure that things are made easy for the RAF from a practical perspective, but it's really about finding that balance. And on the evidence before the committee, it appears to illustrate that rather than improving efficiency, the introduction of the 2022 RAF 1 form had the opposite effect. It made the claim process largely accessible. And it must be asked then whether a claim unfairly denied can ever said to be more efficient than a claim delayed. So we must ask this question: would it be better for a claimant to have their claim delayed and take some years to get through the system, or would it be better for the claimant not to have their claim registered at all? And I think the answer would be fairly obvious. Justice delayed in this case would be better than not having any justice at all. The next question that we looked at was whether the decision to pursue litigation in respect of the 2022 RAF 1 form was rational and defendable. And firstly, we note that notwithstanding a plethora of adverse court judgments, the RAF has really lost it at every turn. The RAF continues to utilize this impugned 2022 RAF 1 form. And they continue at the expense of taxpayers to litigate against the LPIFF in respect of same, as well as in numerous other matters where claimants have challenged the non-acceptance of their claims. By way of example, as part of their submissions to the committee, the Law Society provided us with a judgment of the High Court it was Circuit Court sitting at Thembalethu, in which the court considered the RAF's refusal to accept claims from 16 different claimants. And even though those were separate matters, the court dealt with it as one matter, and the court found in respect of each of those claimants that they had substantially complied and that the RAF ought to have accepted their RAT1 claim forms. And what was interesting in that matter is that the way in which the court dealt with it was on the basis of an assumption that Board Notice 271 and the RAF1 form were legally compliant. So in other words, those are lawful documents, but notwithstanding saying the court then still applied the substantial compliance test and found that the RAF ought to have accepted it. Mr. Harben, and on this point, Chair, I must also just mention that there are numerous cases. Members can Google if they're interested, but there really is multiple cases, and they're coming out of the courts almost daily, in which applicants are challenging the fact that their claims haven't been lodged. And in all of those cases, the RAF is losing, but nonetheless, they continue to pursue the use of the RAF1 form until such time as they can get legal certainty on it. And Mr. Harben described the litigation to the committee and said that in their view, he described it as unmeritorious litigation. The fact that the RAF keeps losing, but yet they continue to litigate. And he also mentions the fact that the RAF is going to the SCA in order to defend a decision of the Minister of Transport, which the Minister itself decided to abide by. And he also said that in his view, it's fruitless and wasteful expenditure, and the RAF is spending money. In essence, it's only going to defer liability that's going to ultimately end up on its books. And he had indicated to us that at that stage, the LPIFF had spent about 2 million in respect of this litigation. So in addition, the committee notes now the fact that the former Minister of Transport elected not to participate in the Board Notice 271 matter. And notwithstanding a change of ministers, the situation persists because the litigation persists. So they still not participating in the litigation. And so the RAF is litigating. Curiously, they're defending the position of another functionary, because they ultimately didn't take the decision to pass the 2022 RAF1 form. And they do so without the benefit of the main central role player. And that's obviously going to lessen your prospects of success, especially because there is no record to explain or justify the minister's decision. So had the minister chosen to abide, but in fact the minister had recorded the rationale for the decision and there was evidence of the public participation, and that the minister had considered comments and so on, that would have been a different issue. But in this case, they're almost litigating blindly. So whilst the committee respects and recognizes the right of any person or institution to defend their decisions and to litigate if necessary, it is concerning that the RAF has not taken the decision to halt the implementation of Board Notice 271 and the use of the 2022 RAF1 form, pending the litigation in the Board Notice 271 matter and the Mautla matter. And the result is that they then face litigation on a daily basis in respect of that. And then lastly, the committee also notes that the right to litigate must be weighed against the prospect of success. There are matters in which the Auditor General has found that expenses incurred in litigation are fruitless and wasteful, because if you know your prospects of success are so low, one would have to weigh that against whether whether one should litigate or not, because any money you spend, you must spend it reasonably. And it would appear, based on the matter to date and all the various court judgments, that the prospect of success would be really slim in this matter. But yet the RAF persists in litigating. The next aspect we deal with is the impact of the introduction of this 2022 RAF1 form, including the financial and potential financial impact of same. And we had various witnesses that spoke to us about the impact of the form. And what we tried to do was divvy it up just to make it a little bit clearer for members. The first was that the form is complex, it's difficult to comply with, and it's costly because of the onerous requirements. And that is to the detriment of claimants, especially the most vulnerable in our society. So those that are illiterate, those that are poor, those that are based in remote and rural areas. The very first person I think that we spoke to that indicated just how difficult the form was Ms. Mtia, who was the senior marketing manager. And members will recall very well that she had indicated that she's got an MBA and that she can't fill out that RAF1 form. And in her view, the implication of the form, essentially what you're saying to claimants is that you're going to have to go and see a lawyer. Because if somebody as educated as she is not able to fill in the form, there's absolutely no way that an ordinary person would be able to do that. She told the committee that the requirements are costly, claimants can't afford to pay. This was Ms. Mtetwa rather, who explained to us how costly the requirements are, that claimants can't afford to pay it. And the result of that is that a claimant either has to abandon the claim because I simply don't have the money to put together this long list of documents and information I need, or I need to find an attorney who's able in the interim to carry the cost. So you do have some of the bigger law firms or the law firms that are specializing in RAF matters that would be willing to carry those costs. And then once the matter is settled, they would obviously set off the monies that they've spent against that. But in the absence of you not being able to find an attorney willing to do that, you really then wouldn't have a choice but to abandon that claim or try to raise funds somehow in order to pay those costs. And Ms. Mtetwa's evidence was supported by Mr. Harbin, and he explained in some detail what the impact was, and members will recall that he used an example that he carried Sipho Zwane, if I recall correctly, that he carried out throughout his testimony. And he said that it's even difficult for attorneys who specialize in this type of work to meet those requirements. So in his view, it would be then impossible for an ordinary claimant, especially a poor claimant in a rural area, to be able to comply. He also indicated that the requirements are impractical and they're extremely difficult to meet. And he gave us two examples. The one was a death claim where you need to give an inquest report. That's one of the requirements, that you need a copy of an inquest report if there was an inquest. And he indicated that these things take years to be for a person to be able to get that report, because these inquests don't happen very quickly. There's a long backlog in respect of inquests. And another example he gave us is that they want VAT invoices for death claims for all expenses associated with a funeral. And he said, many of the funeral parlors and so on are smaller, or these persons making the claims have actually paid for funerals by getting money from family members or some other funeral scheme. So they're not going to be in a position to supply VAT invoices. Those invoices simply won't exist, which means really right at the beginning, they then kicked out because they're unable to comply. Then Miss Lindy Lagner of the Law Society of South Africa also explained that the documentation required in respect of injuries and future claims won't necessarily be available at the time of lodgement, and that would make compliance impossible at that point. And she explained to us the concept of, or rather it was Chair in fact that explained, and she agreed, the concept of maximum medical impairment, which is the point when an injured person's condition or injury has stabilized and they're unlikely to improve in the future. So in other words, your injuries have settled. It would only be at that point that I would know whether I'm able then to continue doing the work that I was doing prior to my accident or not. So I can't provide meaningful and accurate information. If I'm somebody, let's say I'm a massage therapist and I work with my hands and my hands have been injured, I may have to undergo several surgeries, until some months later, doctors are able to say to me, you can now resume using your hands to do the job that you were doing. You're now rehabilitated to the extent that you can resume, or perhaps you can only resume but partially. And what she was saying is that at the time that you lodge the claim, you may not have that information. And you want to lodge the claim because you want to interrupt prescription. So you may not know at this point how long it's going to take you to get that information. So what you want to do in the meantime, and any lawyer that's representing you would ensure that you lodge your claim, because you don't want a case where the claim is prescribed and now only you have your report from your doctor indicating what you are or not able to do based on your injuries. I thought Mr. Songilwa summed it up quite well in his affidavit to the committee, where he said the more stringent RAF1 form delays registration of otherwise valid claims, particularly for unrepresented, unsophisticated, and lower income claimants. They are therefore prejudiced by their lack of wherewithal and resources. And that really sums it up. So, in light of the testimony and evidence before the committee also sought to ascertain what the lived experience of claimants are who are trying to submit a RAF1 form. And for this reason, we visited the RAF offices in Johannesburg during our oversight visit. So members would be aware of that themselves, because I know members had interacted to some extent with persons that we found there. Two of our members had attempted to lodge claims themselves, and those claims were actually genuine claims that they were trying to lodge, and both those members were unsuccessful. So what they had done was that they ensured that the claim was in compliance with the requirements in the 2008 RAF1 form, but it didn't have all of the necessary information as required in the 2022 form. And their attempt was obviously unsuccessful. Instead, they were provided with a list of outstanding information and documents that they would need to come back with. So accordingly, their attempt to lodge a claim was not recorded on the ICMS system, and they weren't allocated a link number. So in other words, in those cases, your prescription would still be running. And the members can correct me if the statement is incorrect, but they were also not provided with any offers of assistance to secure the outstanding information and documents. Former board member Dr. Mabuya acknowledged that the board was aware that the requirements for claimants to obtain the medical, actuarial, and other reports place a significant financial burden on them. And she agreed with concerns raised before the committee that it's nearly impossible for people in disadvantaged areas to access these expensive reports, especially in light of the fact that those RAF satellite offices no longer exist, and you don't have RAF really going out on the ground anymore. So that's fairly interesting, because I think it would be reasonable to say that any person that read that list of requirements, whether you were in the medical profession or not, whether you were in the legal profession or not, would be able to look at that list and see that it would be quite difficult to comply with, and that it's going to attract costs because of the nature of those medical specialists' report. So it's clear that notwithstanding the RAF's position, and this comes directly from their website, that part of investments are to make the claims process simpler and more efficient, is that the reality is that the process is anything but simple and efficient. It really is the exact opposite. The second impact is that the 2022 RAF1 form increases litigation and it results in additional administrative burdens. And the president of the South African Law Society, he explained that there's an added administrative burden on the courts now, because in the past, the courts were really concerned only with the question of liability and quantum, because a claim had been registered and you now have a case where somebody is unhappy with the offer being made or the fact that no offer is made. Now the courts have an added burden in that they're now being faced with litigation around lodgement of the claim, something that wouldn't have happened prior to this new RAF1 form. And this increases legal costs and it further exposes attorneys and their appointed advocates to financial risk while delaying settlements for victims of MVAs. And he emphasized that if the RAF's claim process was simplified, if they were properly resourced and efficiently managed, much of the litigation and related costs could be avoided, thereby improving access to justice for claimants. That they've adopted the RAF1 form to ensure that they can comply within 120 days. But it seems that no one asked the question of what, besides the fact that you maybe don't have all of the necessary information, what else makes it difficult in those 120 days to comply? Is it the fact that you don't have enough resources? Where can we strengthen relationships, for example, with SAPs, with hospitals, or whatever we need to do to try to get us information to the point that we can make an offer? Does the Act need to be changed? Is that time frame extremely unreasonable, and so on? That appears really not to have been done. And the cost of the additional litigation is then compounded by the fact that the RAF lacks adequate legal resources. And we deal with that in a separate part of the report. But where you have cases where claimants fail to successfully lodge their claim, they then run to court. And if there's an absence of a defense there, if the RAF doesn't pitch up or appear in court, that's going to result in adverse cost orders and default judgments against the RAF. And to further make that even worse is the fact that those matters that are in court are in respect of matters that haven't even been lodged. So in other words, there's no claim numbers or link numbers. As I've indicated, there's nothing on the ICMS system at that point, but yet there is a judgment, an adverse judgment in favor of a claimant, and the RAF has to make good on that judgment, yet they have absolutely no record of the claim. So of course, that's going to create administrative issues. The third impact is that the RAF1 form, together with the dismantling of the direct claim strategy, creates a barrier for claimants to access assistance from the RAF. And we dealt with in some detail about the direct claims strategy. And Mr. Songelwa had indicated that, ordinarily you would receive assistance from the RAF's claim officers to process a claim once your claim is registered on the system. But of course, if your claim's not registered on the system, you're not going to get any assistance. And that's now exacerbated also by the fact that direct claim strategy is dismantled. We don't have the satellite offices anymore. And Ms. Mtetwa had taken the committee. She had painted that picture for us in some detail, but what I've included here is a quote from Ms. Rambauli, who was the former acting chief operating, clearly acknowledges this impact. So funny enough, she gave us some detail about the fact that there are these gaps now because the people that would usually help you and assist you are not there anymore, the people to guide you through the process. But she did also say that the form was never meant to create an administrative burden to the claimant. It is just that there were just many moving parts that created the vacuum and ultimately led to unintended consequences that the RAF may find itself. So interestingly, it seems, and this goes again to this whole question of rationality. because whether we accept that it's only the minister that could have passed made regulations on the RAF 1 form, or whether it was the RAF itself, this question is still hanging. Why did the RAF not recognize the fact that this is going to be extremely difficult for claimants to comply with? And what was the bigger impact then if claimants were not able to comply with it? It seems to be an afterthought. The fourth impact that we considered was that the adoption of this form has led to a significant drop in registered claims, thereby defeating the objective of the Act. The objective of the Act is to pay compensation to people that have been in accidents. So the committee heard evidence that the impact of the new requirements was that the number of registered claims dropped significantly, and Mr. Charakupa testified that claims registrations dropped in 2024 from 1,963 claims per week. Oh, now I don't have it, it's missing. Sorry, just give me a second, to 351 claims per week, a decline which he attributed to the implementation of the new RAF 1 form, and also the fact that there was a dismantling of direct claims. And we've included a graph to show the movement of claims from 2018-19 to the 2024-2025 financial year. And as shown in the graph, the new claims registered decreased over the 7-year period. And that decrease is quite significant. We've then also included the second graph, which shows the number of claims that were pre-assessed since the inception of the 2022 RAF 1 form. And from a total of 105,000 claims that were pre-assessed, only 28% of claims were fully compliant. The majority of claims were found to be non-compliant. So, essentially you've got 72% of people that are walking through the door that have to simply turn around and walk straight back out because their claim can't be lodged because of non-compliance. There's no evidence before the committee that the reduction in the registration can be attributed to lower motor vehicle accident rates, because obviously we know the more accidents there are, the more claims the RAF is going to receive. So accordingly, the impact of the reduction in the registration of claims is that the objective of the RAF Act, which is to provide compensation, is not being fully realized. And this is extremely concerning because the RAF is funded by means of a fuel levy that's being paid for by every single road user in order for those users to be afforded protection in law in the case of an accident. Just to note that we have requested accident statistics. There are unfortunately no accident statistics that show the number or the total number of motor vehicle accidents in the country, the total number of injuries and so on. Apparently there are statistics that deal with death, and we're just waiting on the RAF to confirm those numbers for us. But even if one were to accept that since 2022 there are less car accidents, I think it's clear that it can't be a case that the car accidents have reduced to such an extent to justify the reduction in the number of claims. It simply wouldn't make sense. If anything, you would find that accident statistics, because we do have it, for example, for periods over Easter and Christmas, that those statistics show that the numbers really stay consistent. The fifth impact is potential wasteful expenditure in respect of the ICMS system. So we had senior management appear before us and the exec on the implementation of Project Bokamuso, which sought, as members know, to modernize the claims process. And we will deal with this ICMS system in another. I see chairs indicating that the stats were sent this morning. That they have, we'll deal with this in another section of the report, but the whole purpose of that project and this ICMS system was to modernize the claims process. And members will remember that they took us through the system by showing us in that first meeting what the system looks like and all the various options and how things would be passed from one claims handler to the next to minimize corruption and so on. The ICMS contract is a 5-year contract, and it was for an all-inclusive fee of 841.92 million. And during oral evidence, the suspended acting claims chief officer explained that the RAF1 form is the basis of the system. So in other words, when designing the system, the RAF1 form was used to design what the process flow. So the system is designed based on those requirements. And they had said that, notwithstanding substantial compliance in terms of the new solution, they want everything upfront. So we want you to be fully compliant for the claim to really progress forward to the next stages. So the committee spent some time engaging the RAF on what the impact is going to be if the RAF is not successful in respect of the litigation on the RAF1 form. So if that form is ultimately decided by the courts to be an unlawful form, what is your game plan? Because you've now built a system around that RAF1 form. And they seem to suggest that it's not a cause for serious concern. They said, but I think, from a foresight perspective, we sort of understood that the landscape that the fund operates in, we need to build these capabilities in such a way that the solution is agile enough to make these changes. However, the RAF seems not to have taken any legal advice relating to the legality of that 2022 RAF1 form vis-a-vis the ICMS. As such, there is an appreciable risk that should they be unsuccessful in the litigation, they would now have to load large volumes of historic claims that were previously rejected. So in our example, the claims that our members had tried to lodge, and they would need to amend the current system's process flow now to get all of that onto the system. That's going to obviously create significant and a costly administrative burden. And of particular concern, as I've indicated earlier, is that the system doesn't contain any record of those claims which have not been accepted as valid. As such, there's also a likelihood that those claims will prescribe and that the prescription will not be curable, as there may not be evidence of the attempt to lodge a claim. So where somebody came to the RAF officers, tried to lodge their claim, and they were given a long list of documents that they had to go and try to source until before their claim could be lodged, those persons may have gone now at great cost, expense, time, and effort to try and get those documents. But in the meantime, their claims may prescribe. If their claims prescribe, you then sit with a situation where that prescription cannot be cured. That prescription is by operation of law, so there's nothing that those claimants can do. Whereas if there was a record of the fact that the claimants had submitted something and they'd been given a claim number, at least the prescription would have been interrupted, which would have then at least protected those claimants. And these concerns are echoed by the Office of the Auditor General, and who's been flagging these risks related to the 2022 RAF1 form. And when we had the AXA before us during the orientation phase of hearings, they indicated to us that the first risk that they identified was the fact that the form is being contested at court. And then the second risk was with regard to the delays, that it's not going to be implemented on time, meaning the ICMS system, because it was running behind schedule. And the third risk, which is now important, was the fact that the solution might not meet the business requirements. And they raised those risks and they highlighted it to management. And when they followed up with regards to the RAF1 form, they found that the RAF had adopted no mitigation strategies whatsoever. When they asked them what they had done, they had said, no, we need to see what mitigation are you going, or the XRR you're going to have, because if you do not win, you need to go back and reconfigure the system. And what will the impact of that reconfiguration be on the budget? And the RAF appears not to have done that. In fact, the AXA went so far as to say, to warn them that it may lead to fruitless and wasteful expenditure if they don't win, because they now need to change the system. The sixth impact was the potential increased liabilities resulting in expenses that have not been budgeted for. So if the RAF is not successful in defending the 2022 RAF 1 form, the result is that you're going to face a massive influx of claims which comply with the 2008 form. And the practical effect of this, and it places the RAF in a very precarious position, is that they're unlikely to have the necessary financial means to settle those claims, because they simply have ignored those claims, haven't considered those claims as liabilities. The RAF is unlikely to have the necessary human resources to deal with the administration. It's going to be a huge administrative burden on them. They're likely to face an increase in litigation, because then in terms of the Act, they're not going to be able to comply with the time periods given for them to settle claims. And then in the absence of adequate legal resources, they're likely to incur additional adverse costs in the form of default judgments. So already you have a case where they simply don't have enough people to defend those claims that they've accepted. What is going to happen when you now have an influx of all of these claims that they haven't accepted since 2022 now coming into the system? You simply just won't have enough people. And then any default judgments are going to give rise to additional costs and interest. And as we've seen, that ends up with the attachments of goods. And when goods are attached, that has an impact then on staff, because the only thing to attach in an office of any value are tools of trade. So the sheriff comes in and attaches things like laptops, the chairs people sit on, and so on. They're not attaching paper. And that then is going to have a ripple effect that those staff are unable to perform their duties. And when you're unable to defend claims, it's likely that you're also going to end up paying more per claim than what is reasonable in the circumstances. So where matters go to court and those matters are undefended, and a claimant says, I have a medical report and an actuary report that together show that my future financial or my loss of income is going to be X. The court doesn't then, in an undefended matter, have anything else in front of them to negate that. So the court is then forced to award without the benefit of a counter argument there, and that obviously is going to cause an increase in the cost per claim. And in fact, we've already seen an increase in the cost per claim. So this cumulatively is going to have severe financial consequences on the business of the RAF. And in turn, that's going to have a negative knock-on effect on claimants and then society as a whole, because where you have people that have been involved in these accidents that do not have access to the healthcare, the funds that they need, it then becomes a burden really on society as a whole, and it's not just a burden on that particular person. Those were the impacts that we had noted. And now to the last part on observations and findings. This is just where we try to tie together what we've said earlier. The introduction of the 2022 RAF 1 form and Board Notice 271 has resulted in an exceptionally onerous, impractical, and costly claims filing process. The fact that the form is only available in English and requires a vast number of documents makes the process cumbersome rather than more efficient as claimed by the RAF. Unfortunately, this obviously means the most marginalized claimants suffer. Then claimants are further essentially prevented from lodging direct claims, as the complexity and expense associating with lodging a claim makes it impractical for claimants to lodge a claim without the assistance of attorneys. These initial costs can easily exceed 100,000, a sum which is simply out of reach for ordinary claimants. In turn, attorneys, especially those with small and medium-sized practices, are unlikely to have the risk appetite and the financial resources to process claims of claimants who are unable to fund the sourcing of those records themselves. Attorneys are not going to very easily take on this risk because there's always the chance that the claim is not ever going to be registered and the claim then prescribes. Because every time I submit documents, I'm told I need something else and I need additional information. So it's unlikely that you're going to get a small and medium-sized practice firm willing to take this up or willing to bear these costs. The risk is quite a lot. And unfortunately, the majority of those firms are Black-owned firms. So in effect, this is now also having an impact on those attorneys. And we're impacting their ability to practice also. The committee is further concerned that some of this information and these records cannot practically be provided at that stage. And by way of example, we note the medical record substantiating permanent disability and loss of earnings, post-mortem or inquest report and tax invoices. And in any event, we note that these documents should not be required for simply lodging a claim for purposes of interrupting prescription. It appears that the introduction of the 2022 RAF1 form has only increased costs given the legal consequences and the plethora of litigation as a result of same. And these are costs to the RAF. The committee notes further with concern that there appears to be a trend in which the board was not aware of or fully apprised of all information necessary for it to take rational and legally sound decisions. There is no evidence that the former board properly interrogated management on the legality of the proposed changes to the RAF1 form. On the contrary, they signed off on that management directive ex post facto. So they appear to merely just rubber stamp a decision taken by the executive management. And that's very concerning given that it ought to have been obvious that the adoption of the form was going to have severe practical implications. But it appears from what we have in terms of those minutes of that meeting that the board simply didn't interrogate that at all. Then even more concerning, I've said this already, is the fact that the board didn't consider the impact on claimants. And so we find that the board has acted irrationally in approving that management directive. And it's really that management directive that is then the impetus for everything else that follows thereafter. Had the board at that stage indicated that we need to follow a public participation procedure, we need to try to unpack what the impact is on claimants. We need to make sure that we balance the rights of claimants on one hand, along with our duties on the other hand. Then we probably wouldn't have ended up with the saga that we have ended up with. It may be that the RAF1 form would have changed, but perhaps it would have changed in a manner that then balanced those competing interests. The failure of the RAF then to register claims based on non-compliance has increased litigation costs as claimants are compelled to seek court intervention to have their claims accepted. And consequently, this has contributed to a dramatic surge in contingent liabilities, which have risen from the 2022-2023 financial year from the amount of 656.6 million to 1.7 billion in the last financial year. And that's taken from annual reports. The committee notes that the ICMS system, which was developed at a cost which already exceeds 500 million, may not be fit for purpose and will require amendments if the courts uphold the finding that the form is unlawful. And it's extremely concerning that the RAF has not appeared to put any plan in place to deal with the potential eventuality of same. And that wouldn't just be putting plans in place to deal with those additional costs, but also, as I've indicated, the costs that are going to be associated with the administrative plans that you would need to put into place for people to actually sit and now put all of these things onto the system and so on. Accordingly, the committee finds that the RAF management and former board, and to the extent that the current board has not put a moratorium on the use of the 2022 RAF 1 form, have acted recklessly in continuing to insist on using that form in light of the legal advice provided to management. Instead of engaging in legal battles, the RAF, with the support of the minister, ought to have engaged its time and resources to propose amendments to the RAF Act to ensure that the fund can operate efficiently and effectively and in a manner that balance its limitations and obligations against the rights of claimants. So this really has been the story throughout the inquiry, that things that ought to have been dealt with via amendment of the Act have simply been dealt with by management implementing their own decisions. So notwithstanding that you have the law saying X, you have management saying, well, let's actually make it Y because we think Y is better. And there's a reason that these things are put in legislation in the first place, and that they're not left to entities to decide for themselves because of the impact, the cost, and so on involved. And legislation, as members know, goes through a very rigorous process. It gets checked at various stages. There's public participation at various stages. So even in Parliament, if some of these changes wanted to be made to the Act, for example, the changes that Senior Counsel was proposing to Section 24 of the Act, those things would have undergone a vigorous process prior to coming to Parliament and once in Parliament itself. But at least you know that once you've passed that stage, that we really have tested as far as possible. Of course, an Act once passed can always be challenged. That happens every single day. But at least you've subjected it to a more thorough process certainly than what appears to have been done in this case. And then the RAFs instead chosen to litigate and defend the adoption of the RAF 1 form. Notwithstanding that the minister responsible for issuing the form chose not to defend the decision or to participate in the litigation. And it's perplexing that the RAF believes it's able to defend a decision that it didn't take if the decision maker themselves is declining to do so. And it's further reasonable to assume that the minister's decision not to do so was based on legal advice that the prospects of success are limited, especially because the minister was alerted to the fact that there should have been public participation. That the RAF litigated regardless is thus an anomaly which cannot be ignored and raises questions as to whether the litigation in this regard can be classified as fruitless and wasteful expenditure. And of course, we wait to see what the outcome of those challenges will be. Already we know that the RAF has spent about 2 million on the litigation, and I suspect that that figure might be higher from the side of the RAF. Lastly, the RAF 1 form is set aside without possibility of further legal recourse by the RAF. The result will have devastating financial consequences for the RAF and claimants, as they've simply failed to recognize these claims as liabilities. And that's compounded by IPSAS 42, but of course we know from the new board that they're not challenging that any longer. They're thus unlikely to have the capacity, resources, and funds to process the claims further. Thank you, Chair. That was a mouthful. I hope that members followed, but I'm willing to assist with any questions. Thank you.
All right, thank you very much, Ms. Ibrahim. That's much appreciated, and the level of detail and the research done into some of the judgment. I would like to give the honorable members an opportunity to make comments and suggestions in respect of this section of the report. So I will open up the floor for that purpose. All right, honorable. Okay, so we'll take 3 in a row. So we'll take Honorable Mende, then we'll take Honorable Atkinson, and then we'll take Honorable Beasley. Honorable Mende, you go first.
Thank you very much, Chair, and good morning to all the colleagues on the call. Let's also give some gratitude and thanks to the team for this part of RAF 1. It's very clear, it's very detailed, and I concur with you. I just would like them then to look at one area, in rather two areas, where I cannot recall which of the witnesses mentioned these two areas when we were asking about the impact of the current legislation in the claims process, which then, according to the previous board, how they were trying to curb the shortfalls around the legislation by producing this RAF 1, which became a much more cumbersome and not so favorable solution. Two areas, if we can explain the previous process that they were utilizing. I think in the first three paragraphs, it's mentioned, but it's not so clear. I'm saying this because that is what the courts are accepting versus what this RAF 1 form has now created, a whole new crisis where the courts are now overturning everything around the RAF 1. So just help us to uplift the shortfalls of RAF 4 that they must look into in terms of strengthening, or rather utilize to curb their suspicion that the RAF 4 is much more open to people that are fraudulently claiming, something to that effect. And then the second thing is the AMA guidelines, which is the American Medical Association guides that they are utilizing, which also become a tool that is utilized by many to come and claim a draft fraudulently, because the system of America, which is in use at draft, doesn't necessarily talk to the requirements of many people that they have to provide. I think one person made an example when we're talking to the issue of brain versus hands, that if ever you are in America, you don't go to the river to fetch water. So in South Africa, if you are injured on a head, you may be healed, but you may not be able to put a bucket on your head anymore. And yet that's the way of you sourcing water to your house. And those guidelines then in a way are blocking a lot of people from claiming more. So in this type of RAF 1 form, they are trying to address issues that they see as shortfalls in the system, and also trying to tighten the system. But at the same time, their tightening of a system is disqualifying a lot of legitimate claimants. So I'm trying, Chair, to assist our team to find a way to coin that particular area and make an input on it around the required areas of a form, and what would then be our recommendation in terms of security features of a form versus making it much more impossible for the people to claim. Thank you very much, Chair.
Thanks very much, Honorable Mente. Those are well noted. I do think, in fact, that I'm just trying to remember which document I saw which set out how the old process was working. In fact, oh yes, the RAF, right in the first week, and I'll talk to the team about this if you recall, we asked them to give us the ABCs of how the claim system works. I think let's go there and maybe look at the presentations team, because I think that was set out at the beginning. But also, I think in our recommendations, having looked at that, we then need to look at ways in which fraudulent entries can be weeded out. But I think, Honorable Member, there was a diagram that was shared by the Road Accident Fund, the before and after. It was presented by Mr. Match, Tsepo Match. So, but thank you very much for that. Honorable Atkinson. Honorable Atkinson, are you submarining? Okay, maybe he's got a computer challenge for now. Let's go to Honorable Beasley.
Thank you, Chair, and greetings,
Also-
everybody. And
Yeah, go ahead. Go ahead.
and just thanks to the team for that incredible documentation. Chair, when I listen to this, I'm actually going cold. I really am. This when the final judgment comes on this new RAF form, I mean, the RAF is broken. It is completely broken. This is going to destroy the RAF, but more importantly, the impact on the fiscus, our country. I put a figure of 500 billion on the table, and many people laughed at me. It's going to be more than 500 billion, Chair. And I don't think we're highlighting this enough, that the impact on the fiscus is just enormous. Everybody's got their head in the sand and saying this problem is going to go away. It's not going to go away. When the final judgment is awarded on this, it's going to be a tsunami. I don't even know what's bigger than a tsunami. There's no way RAF can handle administration legally, financially. It's just going to explode the RAF, and I don't think we're highlighting that enough in this report. We've got a clause there. I think the final clause talks to it, but I would like us to put an estimate of what this liability is, and not from Beasley, but from somebody, an actuary or somebody, because we need to highlight this risk that is the fiscus. It's not a risk; it's a risk that's coming, that's real. And it just makes me so cold, Chair. For future generations, we're talking 500 billion rand. It's enormous, and I think we've got to put a figure to it, because if we don't and draw people's attention to it, people are going to keep their head in their sand. And then just some other points too is just to help understand, if somebody hasn't done the form, they've gone there, they've seen the new RA form, they've seen it's too difficult, they haven't done it, do those people automatically lose their right to submit a claim when the RAF is rejected? And what happens when people have done the form, it's prescribed, but they can actually state under affidavit that they tried to submit the RAF form, but it was rejected. They weren't given a number. Do those people just sadly lose out because that's just life? Maybe we can just get some clarity on that. And then the other point, many of the legal firms have come under huge, what's the word, criticism, because they've made money. But the reality of it, if it wasn't for these legal firms carrying the costs of these beneficiaries, actually nobody would have actually been paid out. So I think some of that criticism might have been undue, because somebody had to carry the risk for those beneficiaries. And if it wasn't for some of those legal firms, no claims would get paid out. And then I think in terms of the rationality, I think it's just quite clear that there's zero rationality behind this decision. Absolutely. Yeah, but Chair, just to sum it up, I just get cold listening to this. The consequences, once a final judgment to RAF and to our country it's a tsunami. Thank you, Chair.
Thank you, Honorable Beasley. I was taking
Hi,
notes of time.
sorry, it's me. It's Patrick Atkinson. I was unable to mute earlier. I apologize.
No worries. Let me just deal quickly with Honorable Beasley's input. It's quite short. So the first is that in the 2025-2026 budget, Honorable Beasley, the Treasury has a revised number of just over 400 billion. There are two ways of filling in the gap. One, asking the Road Accident Fund to quantify an estimate of the rejected claims, because that is the gap between 400 and whatever the number would be. So, but that's linked to my second point, which is what happens to the rejected claims. So when the full panel of the full bench of the Johannesburg High Court rejected RAF 1 form, they instructed the Road Accident Fund to notify the people who had been rejected to submit their claims. And when the Road Accident Fund applied for leave to appeal, the court expressed itself again to say that the fact that they had been granted a leave to appeal in another matter does not mean that they must not implement this part of the court order, because the court expects that those people must be reinstated, all of them. And you will recall or remember that when the Road Accident Fund was here, together with the Auditor General and PwC, I think it was, we kept asking them whether they are in touch with those people. And at first they said yes, but then we asked them how if they are not registered on the system, and they couldn't. So I'm saying I agree with you that we need to put in our recommendation, because it also links to the ICMS, that they must then be prepared to reinstate those claims. Secondly, I think we should take advice on what happens to those that have prescribed. The question on the first one is whether we wait for the court case. I think it's prudent, Honorable Beasley. It would be, in my view, that given the fact that the matter is already before the SCA, it may be that we ask the Road Accident Fund, once the judgment has been delivered and they've looked at the order, to then quantify what it means for the Road Accident Fund in terms of liability, and then report back to SCOPA as well as the Portfolio Committee on Transport. And then we will have an accurate number, I believe. But the baseline at the moment, excluding these rejected claims, is just over 400 billion in terms of the Treasury's calculation. So we might get to over 500 billion, possibly. I don't know if that assists, but those would be my recommendations. Thank you. Honorable Atkinson, back to you.
Yeah, no, thanks very much, Chair. And also just underlining what you said about the potential liability. I think it's, I don't think we should go around shouting huge numbers like in excess of 500 billion, because we actually don't know. And I do believe that Treasury has been doing work with the Road Accident Fund to get a better quantification of what those numbers are. Because I think Treasury is fully aware of the risks involved. So I think rather than us shouting numbers from the rooftops, let's maybe rather have a discussion with Treasury and ask them maybe to come and give a report to us on that, so we can get an accurate hold on that, because I think it's got massive implications for everybody and everything, and we don't want to be putting out inaccurate information or even assuming inaccurate information. But the other thing that comes to pass, I mean, when Mrs. Ibrahim was giving the breakdown of the presentation, is just the fact that almost on a biblical scale, there's been such a waste of money on continually going to court on matters that, as she said, was only a very slim chance of success. And basically, by continuing to allow an illegal board notice to be implemented, they have created a situation where this massive liability has grown far bigger than it should have. So if the claim form had never come into this RAF1 claim form, had never come into place initially, if they hadn't started using that, we would still be in a position of big liabilities, but not the really bad situation we're in at the moment. So my take on this is that when it comes to recommendations, I really do think, because we've found in almost every fiduciary and every respect to what one would expect from board members and from senior members of organizations, that they have completely gone against their fiduciary duties and actually not given stuff consideration. I mean, as Mrs. Ibrahim was saying, things that the minister should have been considering applying his mind to, he didn't. So there's just a whole litany of people blindly not, sort of, going through the undergrowth and basically just doing whatever they wanted, and just completely wasting state money on quite fruitless litigation, knowing, ultimately that the chances of success are very low. So what I'm saying is I really do think we need to make a finding against the CEO and against the board, and look for some sort of recompense from them for the massive costs that they've incurred in legal fees, and also the potential, this liability could break the road accident fund. I mean, they actually, what they've done has got the potential to break the organization. And I really do think that they should be held to account for that. And we can't allow board members and senior executives in government organizations just to blindly go around wasting money in instances where there seems to be a hopeless situation. The other point I wanted to make as well was, as far as curing the fruitless and wasteful expenditure, curing the prescription for many of the people that could have applied but were turned away because they didn't meet the requirements of that of the new RAF form. And Chair, you mentioned the fact that judgment basically went to the road accident fund to approach those people again and get them to reapply. But as was noted, because I mean, when I put that claim form in at RAF, I mean, there was no records kept of me or that claim or anything. So it would be very difficult for them to follow up because they just don't have that data. So what I would like to know is, how is that going to be dealt with, and how are we going to, how is the curing of prescription going to be taken into account? We almost need to have some sort of enabling legislation passed to allow people whose claims are old to actually go back and reapply, because in essence they've been their rights have been seriously badly affected by what is effectively illegal actions. And then just to conclude this, I would just like to congratulate Mrs. Ibrahim. I think she's done an incredible job on the report, and particularly in this piece as well. It's gone into great detail, covering the time frame and everything that happened. So, the results of whatever we get to recommend on this would be very difficult to dispute, because all the facts are there. So no longer are we in a realm of conjecture and guessing and people saying whatever they think is right. We have the absolute black and white information there. And I do think at the end of the day, when this entire report is concluded, it will be the gold standard for dealing with the road accident fund going forward. So I thank her for that, and the team that have helped to put this together. Thank you.
Thanks very much, Honorable Atkinson. I think what we may need to do is that when we put all the sections together, and we've also consolidated, we've also put in recommendations considering all the sections put together, it may be more efficient to look at a range of decisions taken by the board and management, and then see what the general methods of recourse may be in that sense. So we will note what you are saying in respect of seeking recompense from people, but I'm thinking that there are other matters to consider. There is the labor litigation, for instance, the use of external lawyers, etc., etc. There's still a whole range of decisions that we need to look at and look at them in totality, so that we can then make a concise recommendations, but then we are able to expand on the reasons that we give for making those recommendations. So we will note this, Honorable. Honorable Atkinson. Thank you very much. Honorable Neil May.
Thank you, Chair. Sorry, my tablet took a little bit of time to put the mic on. Good morning to yourself and to our colleagues here. Chair, I have made a few observations and a few comments that I want to share. And I want to start with the continued litigation and financial implications. I think it has been mentioned here before by Honourable Atkin, and the concerning pattern of persistent litigation undertaken to defend the decision to change the RAF 1 form. Even in instances where the High Courts have ruled against the Road Accident Fund, despite these rulings, efforts to pursue further legal avenues continued, resulting in what appears to be fruitless and wasteful expenditure. I think that was very clear in the deliberations and also in the report. Chair, what I wanted to recommend that maybe in this report we actually put together reflect the total amount spent on litigation, particularly where such actions were taken against unfavorable judicial outcomes. I think that is important so one can actually see how much was actually spent, and somewhere we can say to the extent of this amount. Chair, something else that I had observed is the undue pressure on the executive authority. The report highlights instances where pressure was placed on the then minister to support the proposed changes, and this raises concern about governance processes and the appropriate relationship between the entity and its executive authority. I think that was something that one picked up in the report. The other area was withholding of legal opinions and board oversight. I think it was noted that not all legal opinions, I think, were shared with the board, and this lack of full disclosure would have significantly limited the board's ability to exercise proper oversight. Now, I'm saying that the CEO was obviously a formidable influencer, and I think if we look at the report from that was Ms. Ibrahim mentioned, that sometimes the board notices were issued after the event. So I think that is an area that, and I'm not saying that we don't hold the board accountable, but I think we look also at the dynamics that played out there. And we have seen it in from the results of the challenges that the officials have had with regards to the CEO. So that was one of the areas that I thought we need to maybe stress, in that when you have such a formidable CEO, how then can a board actually take decisions based on their own thinking? The other area was the lack of consideration for claimants. I think some of it was mentioned, and obviously the board appears not to have adequately considered the impact of proposed changes on claimants, who are the primary beneficiaries of the fund. I think that came out very clear in that. And furthermore, there is insufficient evidence of meaningful public participation in the processes, which also came out through. And given the far-reaching implications of the RAF reform, inclusive consultation and stakeholder engagement should have been a critical component of decision-making. The other area that I just wanted to mention is that, yes, it is understood that the initial intention of the Road Accident Fund was to explore improved mechanisms to address fraudulent claims and curb abuses within the system, including the conduct of certain legal practitioners. However, as reflected in the report, the approach adopted and the subsequent changes introduced did not yield the intended positive outcomes. Instead, the process followed appears to have created further legal and governance challenges, ultimately undermining the very objectives it sought to achieve. And at the same time, it undermined the judicial system. I think that came out very clearly, that that was one of the areas that we did see. Chair, I also wanted to extend my sincere appreciation to Ms. Ibrahim and her team for work well done in compiling the report. The report has been put together in a thorough and structured manner, ensuring that all critical issues are comprehensively covered, and their diligence and attention to detail have greatly contributed to the quality and credibility of this report. Thank you, Chair.
Thanks very much, Honorable May. I think one of the things we have to do is to just look at, again, take all the instances where information was withheld from the board, so that we can then work out what level of responsibility is apportioned to the board and also what is apportioned to management. I think having a formidable CEO is a good thing. It's just that the board is not expected to just shrink in the face of that. It's the whole idea of having a board is to have the check and challenging that needs to take place, a robust discussion so that the quality of the decisions is high. What we see here is in many instances where the board simply did not ask certain questions, and I think we do need to look into that in the end when we've considered everything. Also, the board's failure to also ask for certain reports to be put together for it, because there were also instances where they could have asked for certain information and they simply didn't ask for it. They could have asked for legal advice. They don't ask for legal advice. And I'd also like members in the meantime to just reflect on the ministerial oversight during this period. So the RAF 1 form is published under former Minister Mbalula, and then the matter goes to court eventually under former Minister Chigunga. Former Minister Chigunga simply does not defend the previous minister's decision, but she does not change it either. She just leaves it. And when the matter goes to court, she just says she will abide by the court's decision instead of expressing an opinion, which she could have at the time. So I'd just like members to just reflect on all the parties involved in some of these decisions that we're looking at. There is ministerial oversight, there is board oversight, and then there is management actions. And then we consider what sort of recommendations and final conclusions we make on each of them. Thanks, Honorable May. Honorable Kubeka.
Greetings, Chair, and greetings to the House. No, Chair, I think for me it's more of a, I want to comments today. Just general comments around what we do, especially regarding the Road Accident Fund. Chair, yes, great appreciation for the work that the team has been doing. Concise, straight to the point. And then, Chair, given the recent ruling by the SCA regarding the same thing I've been complaining about, compensating foreigners, illegal and legal foreigners, and speaking about the RAF 1 form, if any one of us has taken an Uber in Cape Town, in Johannesburg, you will find that in Cape Town, 90% of the people who are driving around in Ubers are non-South African. And a lot of them, when you ask them to come into Acacia Park, they can't because they don't have the documentation to come in. And that's Uber drivers. And you also have your 60/60 drivers, the guys who are riding around in motorbikes. We had a conversation yesterday in Scopa where Honorable Maduna was asking that what happens if these people poison the food that you eat or the food that they bring to you? How do you go about tracking who poisoned your food or who killed you or who did whatever? If the people who are driving around in 6060 motorbikes on our roads, no one knows who they are. Now, the likelihood is that because there's a large number of them on the roads, and they are on the roads more frequently than most South Africans, these people are going to be claiming more from the Road Accident Fund than actual South Africans. Because if they are driving around in motorbikes, they're driving around in Ubers, Johannesburg and Cape Town mostly, then it's clear that the Road Accident Fund is going to be inundated with claims from foreigners, both legal and illegal, given what the SCA has just done. So I'm not sure if what needs to happen now, because I'm still complaining about the RAF 1 form still being in English only. Must we now also consider, on top of our own official languages, must we consider reprinting the RAF 1 form in Portuguese, in Yoruba, in Igbo, in Akan, in Twi, in Fente, in Shona, in Ahmarik, in Urdu and Punjab to accommodate these foreigners? I don't know, Chair, I'm just asking rhetorical questions here, and I think for now, I'll hold my comments there. Thank you, Chair.
Thanks very much, Honorable Kupeka. As I understand, the new bill is coming shortly. So let's say, and we had been, I think the Deputy Minister had indicated that the issue of non-South Africans would be cured at that point. So let's see what comes out of that bill. In fact, you also reminding me that of something that Honorable Beasley had mentioned earlier. I think one of the things I'm proposing members we do in the report is to just consider, having looked at everything, we consider the general financial sustainability of the road accident fund. The funding model does not match the mandate at all, in that the road accident fund is asked to produce insurance outcomes without the funding being that of an insurance platform. And that produces the kind of insolvency that the board has clearly been anxious about, of several boards for many, many years. It's inevitable that even if you fixed the road accident fund today and everything was working, there still wouldn't be enough money. That becomes relevant, particularly then in the instance of people who are not South African, somebody who lands at Cape Town Airport and has an accident just outside the airport without paying a fuel levy yet, even, and then they have to be covered by they have to be covered for loss of future income, etc., etc. There is a need for the legislation to just address those issues together with the funding. So thanks, Honorable Kupeka. We'll also note those, because I think even if there is a new bill coming, we still need to make our own comments in our report, and then we take that to the House. Honorable members, I don't know if there's anyone else who has a comment. If not, I can then just talk about next week briefly. You would have received a program with lots of municipalities in it. I have since spoken to the Auditor General's people, and that number is going to be revised to take account of the time available. I think we'll all be exhausted by the time we finish. If we try and finish them in one day, we won't have a quality discussion. So just expect a revised list later today, so that we can make best use of the time next week, where we would be virtual. in our consideration of those briefings, and then we can follow that up with with those municipalities appearing together with the portfolio committee on cooperative governance and traditional affairs. That's one. The second thing that's coming down the line, I have received an approach from the portfolio committee on youth, women, children, and people with disabilities for a possible joint session in June sometime. So when you receive a revised program, it might reflect that. And finally, I understand that the Portfolio Committee on COCTA is not yet done with Nelson Mandela Bay, and that there'll be an invitation for us to sit together about Nelson Mandela Bay. Finally, we had asked Buffalo City and OR Tambo for certain follow-up information. OR Tambo have sent their information, and Buffalo City asked for an extension until 2:00 today. So we will consider then both submissions, and then the information that the members had asked for will then be sent to the members, and then we can decide what next steps to take. The report, it's also useful for the final oversight report pertaining to both municipalities. The final draft is available, but we'll look at it in respect of the new information, the additional information that gets sent, and then that will be distributed to members as well. So, honorable members, if there is nothing in the meantime on this report, we can adjourn and meet next week. Thanks very much to the Secretariat team as well for the work done on today's draft. It was really excellent. Thank you very much.
Thank you, Chair.
Thank you, colleagues.
Thank you, Chair.
Thanks, Chair.